The right to freedom of speech under the United States Constitution. Freedom of speech is the freedom to speak freely without censorship or limitation. The concept dates back for centuries. The right to speech was enshrined in the British Magna Carta in the year 1215. When the First Amendment was incorporated into the Constitution in the Bill of Rights, freedom of speech had a very limited meaning. The provision was designed to prevent licensing, where writers and publishers were forced to request government approval, a license, before publishing and circulating newspapers, books, and other printed materials. This form of pre-circulation censorship, known as prior restraint, is still regarded as the worst form of censorship and regulation. The scope of the free speech right has since been extended significantly and has grown into one of the most powerful individual rights in the United States. Freedom of speech is justified on grounds that it's essential for a democratic government. Free speech creates a marketplace of ideas where truth and undistorted information are highly valued. It provides for freedom of expression. It promotes tolerance of others and equality. Everyone has a right to speak and have their thoughts heard. Speech and freedom of expression, however, are not totally unrestricted in the United States today, as we will discover in the coming slides. Today, speech and other forms of expression are protected from government censorship in the United States. The government can't censor, but it can impose reasonable time, place, and manner restrictions on when, where, and how speech takes place. The courts use strict scrutiny to review state attempts to control the content of speech. This means a law imposed by the state or federal government that inhibits the message being delivered will be invalidated by the court unless the government can show a compelling state purpose for the regulation, prove that there are no better alternative solutions, and demonstrate that the law is narrowly tailored to achieve its goal. As a general rule, state regulations restricting the content of speech are struck down by the courts. Prior restraint, requiring state approval before publishing, is also treated with strict scrutiny and frowned upon by the judiciary. Certain categories of speech, like calls for imminent violence and child pornography, are not protected and will be upheld by the courts based on virtually any government rationale. As with almost all constitutional rights, freedom of speech prevents the government from censorship and regulation. It's applied to the federal government via the Bill of Rights and the Constitution, and applied to the state governments via the 14th Amendment Due Process Clause, that restricts states taking liberty from individuals without due process of law. Freedom of speech is considered one of the liberties that cannot be taken from individuals by the states. The Constitution does not protect individuals from having their speech censored or restricted by other individuals, corporations, or private parties. It applies to state action, censorship by the state of speech in a public forum. However, this limitation was challenged in a case against the PruneYard Shopping Center. The security guards at this private California shopping mall told students circulating leaflets to leave the premises. In the resulting case, the court ruled the students had a right of expression and petition on private property, as long as it was reasonably exercised. Freedom of expression has become such a powerful right that it extends a little beyond pure state action. The PruneYard doctrine privileges protesters who would otherwise be trespassers from being ejected from the property. Freedom of speech may be better described as freedom of expression, as it includes any act of seeking, receiving, and imparting information or ideas, regardless of the medium used. What's protected is the expression of the message, regardless of whether the communication channel is verbal, published books, newspapers, magazines, TV or radio broadcasts, internet websites, letters, t-shirt slogans, even mime, where words are neither uttered nor written. Even unwelcome messages of protest or messages that offend are protected from government intrusion. Symbolic speech usually involves two components, an act and a message. As we've learned, the message is protected, but acts and conduct can be restricted by the state. So burning a US flag is a symbolic act that is protected by the First Amendment. The message of burning the flag is protected speech, and although there have been attempts, flag burning has never quite been outlawed in the United States. Burning your own flag on your own property in a safe way is protected by the Constitution. However, if the flag belongs to the government or someone else, its burning can be considered an illegal act, as this is also destruction of property without the owner's consent. Burning of draft papers is a similarly symbolic act, but this also involves destruction of government property, so was deemed by the courts to be unprotected by the First Amendment. The speech component of symbolic speech is protected. The symbolic act may be open to state regulation. The government is clearly prevented from censoring the speech of individuals. But the state is also restricted from forcing individuals to deliver the government's own messages, as this is likewise considered a form of content control. So, the state of New Hampshire's attempt to force an individual citizen to carry the state's "Live Free or Die" slogan on his automobile license plate was struck down by the Supreme Court. The First Amendment prevents individuals from being forced to carry or deliver the messages of the government. Although the state is restricted from regulating the message, the government is able to control when and how the message is delivered. Yes, the US does support free speech, but this does not mean an individual is free to wake his neighbors in the dead of night, blasting political commentary, opinions, or music through loudspeakers. Some form of speech and expression are controlled by permits. Marches and public speeches are often restricted without permits issued by the government or government officials. It's important that the issuing of these permits is in no way tied to the content, the message. The permit issuing process and its implementation by officials must be content neutral. The authorities are allowed to set up a permit process to control the time, place, and manner that marches and rallies take place. But they're not allowed to pick and choose who gets the permit and who does not. An authority that doesn't approve of Nazi or gay rights organizations does not get to bar them from having a permit. The process has to be content neutral, otherwise it will be held unconstitutional and struck down by the courts. There are certain categories of speech that are not protected and can be regulated by the state. These can be considered as exceptions to the free speech doctrine. Let's group these exceptions into three categories: dangerous speech, harmful lies, and obscenity. Dangerous speech includes inciting imminent unlawful action, speaking to a hostile audience, fighting words, and hate speech forming a true threat. Mere pornography is protected, but obscenity and child pornography are exceptions and can be outlawed. Speech in these categories can be regulated and controlled by the state, unless it's overbroad or vague. A statute restricting speech is vague when a reasonable person cannot tell what speech is prohibited and what speech is not. Almost all fighting word statutes have been struck down in recent years, on the grounds of being overbroad and or vague. The danger with an overbroad or vague statute is that its interpretation can place too much discretion in the hands of the state to regulate, which regulation violates the First Amendment of the Constitution. The state can't draft vague or overbroad laws, then interpret them with bias. Incitement is speech that's directed at and likely to induce imminent unlawful action. To qualify as incitement, speech must form an imminent trigger to violence or other unlawful behavior. Where the incitement exception is designed to protect the object of speech, the hostile audience's exception is designed to protect the speaker himself. While the speaker has a right to speak, the police have a duty to maintain the peace. The First Amendment requires that the police try to control the audience threatening violence and attempting to stop the speaker, only when crowd control is impossible and a threat to breach of the peace is imminent. The hostile audience's exception requires imminent danger of uncontrolled violence before the speaker is prevented from delivering his message. There is a fighting words exception, restricting one individual from inducing another to fight then and there. However, this doctrine has not been invoked for many years and is somewhat dormant. There no longer appear to be any set of words that are sufficient to invoke the fighting words exception. Hate speech is protected only when it forms a true threat, so the use of swastikas is protected, and any regulation to control it would be presumed invalid by the court. However, in a recent case, the court has found that burning of crosses with intent to intimidate can be regulated. The state has an interest in protecting individuals from fear of violence. Speech creating the fear of bodily harm or death can be controlled by the state. Defamation protects individuals from speech that damages their reputation. Defamation refers to libel, written lies, and slander, spoken lies. Libel and slander of private individuals can be punished by the state. However, public figures and public officials are considered fair game. Defamatory speech about a public figure must be accompanied by malice in order to qualify for control and regulation. Lies in advertising fall under the commercial speech exception. False, misleading, or deceitful advertising, or advertising of an illegal product, can be regulated by the state. As a general rule, truthful advertising cannot be restricted. A form of strict scrutiny is applied. However, in-person solicitation by lawyers is banned by state bar associations and upheld in court on the theory that lawyers are unusually persuasive and have the ability to frighten individuals into paying for legal services. Advertising by lawyers was restricted until it was challenged on the basis of freedom of speech, and all regulation in this area was struck down by the courts. Commercial speech is not subject to strict scrutiny by the courts, but intermediate scrutiny, placing the burden on the government to show that the regulation substantially serves an important government purpose. Pornography, sexually explicit communication, is protected speech unless it's obscene, then it forms an exception. The difference between protected pornography and obscene material has been difficult to define. In a famous statement, a Supreme Court judge said obscenity could not be intelligibly defined and resorted to the test of, "I know it when I see it." Today, a more sophisticated three-part test for obscenity is used by the court. Legally speaking, obscenity must be sexy, sickening, and lack serious artistic value. Firstly, the court asks whether the material ignites lust or desire in the average person. Secondly, the court investigates whether the material depicts sexual conduct in an offensive way. To qualify as obscenity, it must be grossly offensive to average members of the public. Finally, the court listens to expert testimony to investigate whether the material lacks any serious artistic value. If these three elements are met, then the speech is considered obscene and can be censored or controlled by the state. Otherwise, mere pornography cannot be censored. Pornography can be zoned, but cannot be censored. The right to freedom of speech extends to the press as well as individuals. A publisher has a right to publish or broadcast a message, and the same constitutional protections apply as to any individual. However, an individual reader of a newspaper does not have a right to have his or her letter responding to a story published. the publisher has a right to pick and choose what material it wants to include in its publications. Alongside the freedom of speech provision in the First Amendment sits the Establishment Clause, creating a freedom of religious expression and a divide between church and state. Congress shall make no law respecting an establishment of religion. The government cannot endorse any religion and must be neutral when dealing with all religions. The Supreme Court has developed 3 tests to be applied to religious practices for determining their constitutionality under the Establishment Clause. However, the following lemon test is perhaps the most common. The court will rule a government practice unconstitutional if 1. It lacks any secular purpose. That is, if the practice lacks any non-religious purpose. 2. The practice or regulation either promotes or inhibits religion. Or 3. The practice excessively, in the court opinion, involves government with a religion. The government cannot restrict an individual from practicing a religion, and it must be neutral when dealing with religious groups and non-religious groups. It cannot endorse or give special benefit or priority to any religious group. School prayers, when forced upon students by the state in state schools, are considered a breach of this neutrality and are not tolerated by the courts. Mandatory devotional Bible study and the posting of the 10 Commandments in the school are likewise found to be an unconstitutional merging of church and state. The study of the Bible alongside texts from other religions in a neutral educational setting is not considered a breach of the Establishment Clause.